everyone. We're here at the ICPA Annual Conference, and I have three buddies here of mine joining me. We're kind of just trying to catch up here with everything that's going on with trade. Some of the sessions were already planned ahead of time, and of course, as you all know, the Supreme Court came down with a ruling. Everybody and their moms have already debated that and talked about it. We want to get the latest and greatest. Today is Monday, March the 2nd. So we're trying to see like what and where we are with the decision. Anything that's like any buzz that we hear like in the hallways, because that's what conferences are for. You know, we listen to, everybody's opinion and all that good stuff. So I invited three of my buddies here to join me. You don't see me on camera, of course, because the set is a little small, but I wanted to let the stars shine here on the camera. So we have Mark Segrist from Sandler, Travis, and Rosenberg, STR. We have, of course, Ms. Cindy Allen from Tradeforce Multiplier. And we have Eric Hargraves from Elliott.
Elliott Davis.
Elliott Davis. Thank you. Thank you, Eric. I'm sorry. I always forget the Davis part. Anyway, but they're going to be having more like a little panel discussion. Eric put together a really nice little framework, and we'll let him take it off. And if something comes up or something comes into my mind, I'll interrupt, but I'll let you all go ahead and go. Thank you, guys.
Lalo, you forgot the most important introduction.
What?
I'm the Taylor Swift of trade.
Oh yes, of course. You're the Taylor Swift of, and she'll be having a little table here on the side to be signing posters and stuff later. But
but they have to listen to Simply Trade Cindy's version
They do.
on Friday for the latest and greatest update.
They do.
All right, let's go ahead and kick this off with a couple of questions. First, for Mark, what did the Supreme Court actually say in their decision? And then secondly, how does the DOJ response on Friday kind of weave into the total narrative of the story?
Yeah, good question. So the opinion was quite long. It was 70 pages. There were some dissenting opinions. There were obviously the majority opinion, but the big picture takeaway, what the court said was that the president of the United States did not have the legal authority from Congress under the IEEPA statute, the International Emergency Economic Powers Act, to impose, changing tariffs whenever he saw fit. I think the court was trying, at least in the Kavanaugh dissent, I noticed very clearly that Justice Kavanaugh kind of laid out what the president could have done, basically saying, hey, Mr. President, you already have the tools to impose tariffs if you want. We just think you maybe used the incorrect tool by using IEEPA, but you could impose additional tariffs under Section 232. You've imposed tariffs under Section 301, these kind of tested, tried and true provisions that it's a little bit clearer in those statutes that Congress has delegated that authority to the president. But I think this was just a big decision because it basically made clear that the president may regulate imports, but regulation does not mean taxing them in terms of tariffs.
So let's unpack that just for a second. And Cindy, you chime in on this as well. The statute, IEEPA, does say regulate importation, and tariffs are widely known to be able to regulate volumes of importation to and from, into the United States. So now that IEEPA has been pulled back, or the IEEPA-based tariffs have been ruled unlawful, what is the kind of pivot point now for the administration? Where do we see them going? What does the decision on Friday by DOJ to put a 90-day stay on any further work?
Well, I would say, as you mentioned, the president immediately pivoted to 122. So we saw IEEPA end at 1201 and 122 started at 1201 the same day. So it was an immediate pivot. A lot of companies and countries did not get a break. Some of them did. The practical application of that was for the trade deals. There was a lot of question of how the trade deals would work once the IEEPA authority was taken away from the president. What happened then? Were they still going to meet that obligation? And I think if you think about the 122 is 10%. And the maximum under the IEEPA trade deal for EU was 15%. So anything over 5% MFN now has an effective higher duty rate of 15%. So what does that mean for the other trade countries that have signed these trade deals? And what does that mean for importers if they were paying, last week they were paying, or the week before they were paying 15%. Now they could be paying the 10% 122 plus a 15% duty rate plus a 301. So it adds up to a larger duty rate for some of those countries.
Sure.
And also it's going to make the refunds process, which I know we're going to touch on in a minute, messy.
Well, Eric, you and I last night were talking with a European practitioner, and his thought was that from a European perspective, they were looking at these deals as anything in the deal that related to Section 232 kind of remains, but anything relating to IEEPA needs to be renegotiated at some point because of that delta issue that you identified, which is that under 122, it's 10%, but under the deal that they sign, it's 15%.
Right.
And so why would a European partner continue to abide by that term? Obviously, the Trump administration came out and said a deal's a deal, right? Trying to leverage that additional 5%, but we'll just kind of have to see how that plays out with those negotiations with the USTR and the rest of those countries.
I think we can all agree it's a mess, considering like the Supreme Court decision ruling IEEPA-based tariffs unlawful now has a broad impact on all these bilateral trade frameworks or agreements. Most of those are pegged to an executive order that was based on IEEPA. And so now it's going to require renegotiation on some level. And while that's happening, everybody's coming in at 10%. And the tariff stacking mechanism is still in play, like you said. So it's creating this delta from what they thought they agreed to what's actually what we can enforce today. So speaking of enforcement, let's talk a bit about the refund process. What does this decision mean for potential refunds that are currently not guaranteed? But let's figure out how we work through that together.
Yeah, that is a complicated issue, but it's one that I know our firm and many others are probably advising companies to exercise what we would consider kind of a belt and suspenders approach. The belt being you want to make sure that if you have entries that have liquidated where you paid IEEPA tariffs, you are actively monitoring the liquidation dates of those entries and you're filing protests within the 180-day protest filing deadline. That's kind of your belt, right? To make sure that if those protests are denied or customs sits on them for such a long period of time while this thing is litigated out, that they could be effectively deemed denials and you could get to court under 1581A of the court's jurisdiction. But for a suspenders additional approach for a lot of clients is filing at the Court of International Trade under 1581I jurisdiction, which is kind of the court's residual jurisdiction. There's a lot of companies, I think there's over close to 3,000 plaintiffs that have filed at this point under 1581I, Costco being the first one that kind of came out and filed that initial complaint. And since then, every week I'm getting calls from people saying, oh, should we file? Should we file? Many clients are leaning towards filing now. I will say that under the statute, you have 2 years under 1581I from the date of the cause of action, which conservatively, if that's February 1st of 2025, when the first IEEPA tariffs took effect, you theoretically would have until February 1st of 2027, 2 years to file under the 1581I. I think a lot of companies are just not going to take the bet there and they want to file right away. So
I think as a trade, we should call that the AEIOU approach. The A, the I, but we know they owe us.
Oh, that's great. That's great.
Let's unpack this from a disruptive standpoint, from a practitioner level decision tree, because we have, going back to the first Trump administration, Section 301, we had the Biden administration sort of double down on Section 301 and increase some of the rates. We saw broad use of Section 232 for national security issues. And now we're in Section 122 for 150 days, but we've already seen signals about a shift to Section 301 investigations taking place, which means further tariff impositions down the line. Is this creating a more disruptive environment for importers, or are we starting to go towards a more rules-based system again? Because Section 301 would require lists of tariff codes impacted, certain tariff rates, almost easier for an importer to wrap their head around in some sense.
Yeah, that's true. And it's not changing and fluctuating as much as maybe IEEPA, which is the concern.
Correct.
I think anytime there's uncertainty, obviously for businesses, it's difficult because uncertainty is kind of a negative term. It's hard to do business when you don't know what's going to happen. I think it would be more predictability there, but the problem is those take time, right? Those investigations take time. And I think it was pretty clear in the press conference that the president said, I want my USTR, Jameson Greer, to do expedited Section 301 investigations or expedited Section 232 investigations, which usually take about a year. There's notice of comment, there's hearings, there's kind of due process involved. My bigger concern is that what happens on 100 day, 150, is the president going to wait a day
Right.
and then reimpose a totally new Section 122 investigation? Or is he going to start maybe using Section 338, which is another kind of hidden dust off that provision from a particular statute, and start using that? So I just don't think we know exactly what's going to happen there as this plays out.
And I would say, there's about 15 to 18 open 232 investigations right now. So this was kind of the administration's hedging their bets. If IEEPA goes away, they've already started the investigations. They're already in process. Pharma has actually gone all the way through the process, and we're just not seeing the duties being assessed yet. So there are some in process, and I think they will speed those up as long as they've met all of the statutory deadlines that are outlined. For me, it's more predictability, but more actions. So it's kind of like a trade-off.
Sure.
We aren't going to have that, tweet that's going to assess duties on Monday morning and it's Sunday night. We are going to have to scramble to understand the language and determine how to apply that. But we're going to see multiple investigations and multiple layers of investigations. One of the things I worry about is not only the derivatives, but what if you have multiple derivatives that fall under multiple 232s? What happens then? It's going to just get so much more complex. And we're going to have kind of spreadsheets going back to the paper-based process of trying to keep track of all this, because it's almost impossible to not just understanding the stacking that we have today, but then in the future, you're going to have so many more. There's a reason that Customs put 30 some lines on one line of entry, 32 tariff numbers. And we all looked at that and laughed. And I don't think we're laughing anymore, because that could be a reality that we have.
Yeah. And you bring up a good point, because while putting everything under 232 or putting everything under 301 may give kind of a bucketed sense of stability for importers, like they know where their product falls. Every time you impose a new tariff regime, 5,000 new questions are created. So you bring up the derivatives.
Yes.
I mean, right now, there's court cases that are filed right now on how you value steel content, right? And so even though your product might be under 232, you're still stuck trying to watch the courts to see what they're doing, because am I valuing my steel content correctly? I've got the base metal centers saying one thing. I've got headquarters kind of saying something a little bit different. What do I follow? What do I do? All of that uncertainty, even though they're all bucketed under 232.
And where are you for reasonable care? How do you determine what reasonable care is, or responsible control and supervision if you're a customs broker? And make sure you're trying to do what's best for your client and try to be compliant and meet the law, the letter of the law. So it's very difficult. I think one of the other interesting things that I've seen is under that 232 investigation for pharmaceuticals, it went through the investigation phase, but it wasn't announced and duties weren't assessed. But what we did see during that time frame is a lot of individual companies go make deals with the administration to say, we're going to build so much here. Company by company by company deals that are being made with the administration. I cannot fathom how that would be multiplied when other 232 subject industries start doing that. Not only will I have to keep track of a country level, a security level, but a company level application of this falls outside of 232, this doesn't. It's going to be even more complex than anti-dumping duty, where you have all of the scope orders and then all of the individual cases. So it's going to be very difficult. It's not going to get easier or simpler. It might just not be as urgent an announcement or an issue.
So I think that's a great point. And I think we're all in agreement, if we sort of read between the lines, that it's getting more complex, more disruptive. And so for those of us who built modern supply chains on three big assumptions that are no longer true, we built them on globalization, we built them on the ease and flow of goods across borders, and we built them on predictable supply and demand. It used to be pretty easy to calculate the predictability of your demand and how your supply would satisfy that demand. And now we're shifting from sort of this just-in-time inventory position to this just-in-case type of inventory position. How can importers really work not just through legal and compliance frameworks, but elevate this function to the strategic level inside the C-suite?
I mean, I think over the last couple of years, trade and customs issues have bubbled up to the top. You know, normally when we would be speaking with maybe a general counsel, or we'd be speaking to somebody, a compliance manager for particular issues, most of those calls had elevated up at this point to the C-suite level individuals, just because it's so front and center and something they need to address. I think the days of customs and trade compliance professionals kind of hiding out in the back closet and just doing their work and processing entries and nobody talks to them about anything. Those are done. You need to be part of the conversation.
The C-suite definitely knows our names now, and they are interested in the information. And I think you can look at that if you open, LinkedIn. There's so many trade compliance jobs at a very high level within these companies. Yeah. People are getting promoted to a C-suite level visibility because of the importance of the information. It is not just a component of your compliance process. It's really being looked at as a central part of your logistics program overall, because if something gets stopped or costs twice as much as it used to because of a duty situation, you don't want to be kept, be caught off guard on that. So it's becoming more central.
Well, and one thing on like the litigation side of things, we haven't really talked. Obviously, there's the litigation with respect to the 301 case that's still kind of pending with the Supreme Court, but then there's also litigation with IEEPA that we just had. But there will be court challenges on 122 as well. Like, has the statute A ever been used before? Does this properly address what a balance of payment deficit is? Does balance of payment mean all services and goods, or does it just mean trade and goods? Is it something else? So that's going to need to be litigated out. I think we're just in a new world where that's going to create more uncertainty for importers. You're just going to have to monitor those court cases that for years maybe you didn't need to worry about. Maybe you had to follow a couple CIT decisions to figure out how something was classified or how the value of something might work. But now it's just overall, does the president have the authority to even use these tariffs for these reasons?
We're moving into very much more litigation. Yeah. I mean, just more and more and more litigious as we're going forward.
Yeah. And one thing I do want to bring up, though, just as a distinction, people ask about, could the president regulate tariffs under IEEPA? I think it's the distinction came down because Article 1, Section 8 of the Constitution says no, taxing is something that Congress controls, right? So the president can regulate it. You can blockade it. You can embargo it. You can do those other things. You just can't tax it because that's a specifically defined function of Congress in the Constitution.
Lalo, how are we doing on time? Great. Let's wrap it up with one more question. And I think this one's very practical. What are the most common misconceptions that an importer might have at this moment in history? What are some of the things that maybe they're getting wrong that we need to help with?
I think the biggest one is that they're gonna be assured getting a refund. I don't see that as a guarantee at all. The decision, as a non-lawyer, reading that decision, it was incredibly narrow, even at 70 pages. All it said is the president doesn't have the authority. Yep. It was silent as to refunds. It was silent as to the process. And also one of the things that I am worried about is a lot of the importers are pushing, a lot of different trade associations are pushing to have automated refunds, which sounds great. Just give me my money back like GSP, and everyone is fine. But what that means is the ACE system, which is the system of record, will not be updated. So importers are going to have to correct their own entries so that they have an accurate representation of what that entry looks like without the IEEPA duty. So I think we have to be very careful what we ask for. And if it is an automated refund, there has to be some assurance that CBP is going to update the entry record itself, because if you have a downstream process like reconciliation or drawback or a PSC or a protest, the information is not going to be accurate in the system. So I worry about that.
Well, that brings exactly to the point where the misconception that maybe importers have is that they're just going to sit back on their heels and hope that they're going to get an automatic refund. I would highly advise to not wait.
Agreed.
File protests. If you get an automatic refund, great. File protests when they liquidate. Consider filing at court if you need to under 1581I, just to preserve your rights, because that's really what you're trying to do at this point as this thing plays.
That's a great place to wrap up. I think if you take anything away from this, it's that there are two paths right now you probably need to be going down. The normal administrative path of PSCs, which are likely getting blocked at the moment, protests, and then also litigation. And then we don't want to sit back and do this wait and see approach, because doing nothing is going to be bad for you eventually. And while we all agree that refunds aren't necessarily guaranteed right now, they're probably likely, but the time between now and when that happens requires you to be on top of your entries and know your protest window and your filing dates. So thank you guys for giving us the time to communicate with you. Thanks to Lalo and his team for setting this up, and hope you're enjoying the conference.
Thank you. Thanks, Eric.